This is Lecture 23, Patent Remedies, Part 1. The agenda for this lecture is to begin with an overview of remedies in the patent law. What are the possibilities? What are the different parameters? But the primary focus of the lecture is on injunctive relief, and so we'll discuss that for most of the class and then look at the special case of preliminary injunctions as well. So let's start with a broad overview of the remedies available in the patent law, right? So patents are enforceable, as you know, from the date of issue until the day they expire. Patents expire in almost all cases, although not every single case, as of 20 years from the date of application for the patent. It's possible in some contexts to get what are called term extensions if you can show that the PTO had an unnecessary and unreasonable delay, and this is particularly important in the pharmaceutical drug context and does happen on occasion. But as a general matter, patents are enforceable from the day they're granted until their term ends, and their term is 20 years long. Now, Section 154B allows collection of a reasonable royalty of damages from the time of the publication of the application until the time of issue, right? So, as we've talked about before, most patent applications are now published after 18 months, right? So after you apply 18 months later, unless you take steps to avoid it by saying you're only going to apply in the U.S., for example, or other measures, then your patent application will be published at that time, whatever state it's in as of 18 months. Section 154B allows you to collect some damages after that time until the date of patent issue, in which point you can then sue and get typical damages and injunctive relief and things like that, right? This is a way of giving some benefit as a trade-off for the publication decision. There are limits to patent recovery. The statute of limitations is the typical federal civil statute of limitations, which is 6 years, right? So you can't get damages more than 6 years back. And if infringement ceases, then you have 6 years to try and collect damages before you can't get those either. There's also the doctrines of latches or implied license. We'll talk about those a little bit later on. Those are equitable principles, case-by-case basis. They come up sometimes. You could put things like patent exhaustion in this category as the basic idea being that it's an implied license when you sell a product embodying a patent that you can't sue anymore, you can't recover. And there's some limitations related to the failure to mark. So if you don't mark your patent number on a good, it doesn't mean you can't recover, but it does make it more complicated, and it can in some cases limit the recovery of damages for certain time periods. It's not something that comes up that often, so we won't talk about it in detail here. I just wanted to flag it for you that there is an incentive to mark your product with the patent number of your patent. All right, so here's the basic types of relief. So from the date of infringement to the date of judgment, right? So date of infringement could be, obviously has to be after the grant of the patent, but could be somewhere thereafter. And then at some point later, there's a judgment date, right? When the court actually determines that infringement has occurred and validity is okay and things like that. You can get damages from the date of infringement to the date of judgment, and that's called retrospective relief. You obviously can't get an injunction during that time period because that time period has already passed, right? So all you get, the only possibility for damages or for retrospective relief is damages. Now going forward, prospective relief is where there are some choices here, right? There's the possibility of injunctive relief, right, which we're going to talk about in this class. There's a possibility of damages, which we're going to talk about in the next class. And there's this other possibility, which is sort of a combination here. It's more like damages, but it's a compulsory license whereby the infringer is allowed to continue to use the patented invention, but must pay a particular amount defined by the court for the time period in which they're using the patented invention. It's often called a compulsory license because it's not a true sort of arm's length transaction. It's similar to damages in the sense that it would be, that because it's prospective, it's not damages for past behavior. It's essentially damages for future infringement, right? So it's a compulsory license in that sense, because it's not one that the patentee would necessarily choose. Might be, but generally patentees would prefer to have an injunction, because injunctions can then always be lifted or not enforced by the patentee for the appropriate deal, right? Again, just because you get an injunction doesn't mean you have to enforce it. It just means that sets the terms of the negotiations between the parties. And there's also a preliminary injunction, right? So the possibility is that during litigation, you can seek to have an injunction for the term of the litigation, an injunction entered against the infringement. We'll talk about that in a few minutes, about when that occurs and why. Okay, turning now to injunctive relief. So injunctive relief means that the court issues an order which bars the patentee, or that bars the infringer from engaging in further infringement, right? Basically, it's an order from the court saying this particular party may not make, use, sell, offer to sell, import a product within, or service, good, service, method within the scope of these claims, right? That's enforceable. It's an enforceable right. You can get, you can go back to the court to try and enforce it, usually through a contempt order. Judges take very, very seriously the violation of their injunctions, and can often result in people being thrown in jail and assets being seized and other types of extreme remedies. So basically, you don't want to violate an injunction, right? So injunctions are powerful. And the core to understanding injunctions, I think, is to understand that we're thinking in this context about patents as property, right? That a patent might be just like a piece of land, right? How is a patent like a piece of land? Is it like a piece of land is in fact an important question, right? So patents are thought to be property rights, and they're enforced by what we call property rules. Well, what does that mean? Well, you'll probably remember a lot of this from property class back when you were 1Ls. But there's basically two ways of thinking about the way that we enforce rights, right? One is property rules, right? Property rules offer an absolute right to exclude, right? When I win my patent case and get an injunction, I have an absolute right to keep you out of the subject matter of my patent. Similarly, if I own a piece of property, a piece of real property, I have the absolute right to keep you off of my lawn, for example, right? And property rules are almost always enforced through an injunction, right? If I need to enforce my right to keep you off my land, then I will go to a court and I'll get an injunction that says you may not be on my land. Similarly, a property rule in the patent context is injunctive relief, right? I win, you are infringing, and therefore I want the injunction that gives me an absolute right to exclude you from the scope of my patent. A liability rule is different. It's simply a right to collect damages, to make yourself whole, right? To make it so that you would be put in a position similar to what you would have been without the infringement, right? It requires a calculation and an award of damages, right? So if somebody trespasses on my lawn, I would not be allowed to automatically exclude them or get an injunction to exclude them. What I would be able to do is get a calculation of the damage, the harm that was done to me as the result of the transgression, and would get that amount of money, right? Similar in the patent context, right? If we're going to award damages as prospective relief, then that is a liability rule enforcement, right? And there's a really, really large scholarly and theoretical literature about the differences between property rules and liability rules and which ones might be better. This is one of the most common things that law professors tend to talk about, which is why you've probably heard it several times throughout your law school career. The basic idea is this, right? So property rules better harness private information about valuation. And why is that? Well, because when I get an injunction, then if there's going to be a deal, then meaning a deal that would allow somebody to continue to say trespass or continue to say infringe my patent, then it would have to be as a result of a deal between myself and whoever's trespassing or infringing. And the idea here is that private information, meaning my information and the information that the infringer has, would be harnessed and brought to bear. And if I thought it was worth to me $1,000 to keep people off my lawn, and and somebody thought it was worth $500 to them to go on my lawn, well, that's private information, right? And we would then have to come to an agreement, probably somewhere between $1,000 and $500. And it would, the valuation, the theory is that valuation would be the closest thing to correct, right, that we can get. Similar in the patent context. If I get an injunction, the injunction, if you simply stop producing the infringing good, that injunction might be worth something to me, but it actually might be worth more to me if I got you to agree to continue producing that good that infringed and give me a portion of the proceeds. And so then we would have to reach a deal about how much you would give me. And again, harnessing the private information that we each have about how much value there is in the activities involved. Liability rules, the theory is that they avoid a number of costs associated with property rules, right? I mean, one of this is, the general concept of transaction costs, right? The problem with property rules, the argument goes, is that it's very difficult and sometimes it's just impossible to reach these deals. It's costly, right? You have to hire lawyers. Valuation is hard, right? Evaluating how much money I should ask for is hard, and it's going to cost money. I'm going to have to hire consultants and economists and things like that. And this all takes time, takes effort, and a lot of times these deals may not even happen. And if they were going to happen, it could be that the total value involved is swamped by the costs, by the transaction costs. So there's not enough of these deals happening, and there's transaction costs and generally a loss to society. Liability rules, the argument goes, they step in because you have a third party, almost always the judge, who establishes the valuation and says, here's the deal. Right? There's no transaction costs involved in there. I mean, there's some you might call the litigation aspects of transaction costs, but it's a lower transaction cost, and the deal will happen. The deal's not going to go away because the judge is going to say what the deal is. Right? And so those are the two ways of thinking about remedies. And the theory sort of plays out in this way. We think that property rules are better when there are fewer parties, when valuation is really difficult, meaning that it would be hard for a judge to do, still hard for private parties to do, but they might have private information and they have the incentive to get it right, and where there's lower transaction costs, right? Again, fewer parties, relatively clear to understand what the rights are. It's going to be easier to reach a deal. Liability rules are better when there's a lot of parties involved because it's very difficult to make a deal between two parties and even more difficult to make a deal between more than two parties. When there's strategic behavior possibilities, right? If somebody might hold out, say, for example, I have a patent on a new kind of light bulb that would be sort of revolutionary to the light bulb industry, but I'm making so much money on the old style light bulbs that I don't want to allow anybody to produce the new light bulbs, so I simply suppress I win all these injunctive relief cases and I don't allow anybody to produce the light bulbs. which is probably a social loss, but it's because of my strategic behavior. Now, whether it would actually happen is another story, but you could imagine cases where patentees might behave strategically rather than purely rationally, right? And the other thing that liability rules are good for is where there's very high transaction costs. Again, judges can cut through the transaction costs and make these deals happen. So the big question here is the policy question is what's better for patents? And this is, the subject of a huge amount of debate, right? Because patents certainly have characteristics that fall into both of these columns. A lot of patent cases just involve two parties. It's very clear that patents are extraordinarily difficult to value, which might tilt towards a property rule regime. On the other hand, there are a lot of patent cases, and increasingly so, where there are more than one interested party involved, right? Where there are multiple parties, multiple patents, very complex. Again, we talked a little bit about the strategic behavior possibility, and a lot of people argue that because of a lot of uncertainty surrounding patents, their scope, their valuation, the transaction costs are very high. It's very difficult to reach an agreement about what a patent is worth in the modern patent system. So the debate is real. My own personal view is that property rules are better. I would focus primarily on the difficulty of valuing patents, and I think that the only way to be sure that you're getting anything close to the correct valuation for patents is to get people, private parties, involved in making the deals, and I just don't think judges are going to be able to do this no matter how many expert witnesses they listen to. And so my general thought is that it's probably better in most cases to allow injunctions to issue, enforce patents via a property rule, and take some of the downsides that are clearly going to occur, right? This is going to cause potential holdouts in some cases, maybe some strategic behavior, but at least in my view, the overall benefit would be more with property rules. But that's a debatable policy choice. As a general matter, until very recently, until the eBay case that we're going to talk about and that you read, the courts were pretty much uniformly in favor of pure property rule enforcement, injunctions almost all the time for patents. So injunctions are authorized by 283. And 283 doesn't say much. What it does say is it just allows injunctions to issue in accordance with the principles of equity, right? So this allows both preliminary and permanent injunctions, right? We talked about preliminary before. And this is the historical approach that the Federal Circuit has taken towards injunctions. You'll probably remember from civil procedure, or maybe if you've taken a remedies class, the 4-factor approach to injunctive relief. First factor is you have to show the person seeking the injunction, here the patentee, has to show irreparable harm, has to show damages are inadequate to compensate for the harm, has to show that the balance of the hardships favor the issuance of the injunction, and show that the public interest either favors the injunction or won't be affected by the injunction. So the Federal Circuit historically had taken the following approach, right? They would always say that irreparable harm was presumed by infringement, right? The argument here was patents are special. Patents, by their definition, are a right to exclude people from the scope of whatever you've invented, and allowing people to trample upon that right would undermine dramatically the incentive structure, the whole point of getting a patent. And so in general, the Federal Circuit would just say if you infringed, there's irreparable harm, right? The idea is it's difficult to uninfringe a patent, right? It's irreparable. You can argue whether that's the correct understanding of what infringement is, but that's the way the Federal Circuit had developed its rules. And the next point is that damages were always inadequate because the Federal Circuit thought that patents were property. Now you might note there's a bit of circularity in this reasoning, and you would be correct. The Federal Circuit for a long time had never really analyzed exactly why damages would be inadequate, but they would sort of go back to this idea that patents are property rights, and because in general, in real property, we think that injunctions or damages are inadequate, injunctions should almost always issue, which turns out actually not to be true in a lot of cases in property law, but in any event, the way that the Federal Circuit thought about property law, it was patents were property and therefore needed to be damages were inadequate. The balance of the hardships, the Federal Circuit always favored the patentee, always said that the harm that's occurring as a result of patent infringement outweighs any possibility of hardships by the infringer. And the public interest, they would talk about the general policy favoring protection of patents. Now, on some occasions, they would use the public interest factor as a way of not issuing an injunction, but those are very limited public interest exceptions, right? And so public health or welfare, I guess one of the cases I remember where they did not issue an injunction had to do with a sewage treatment plant, whereby if an injunction issued, sewage would be released into the wild, right? So you can imagine sort of a public health or public welfare exception to that. But that was sort of the limit, right? Other than that, the Federal Circuit would understand that injunctions should always issue in this context. And they essentially shortcutted the analysis, right? Over the years, they just shortened the analysis since all 3 out of the 4 factors always favor the patentee. So they would just issue, they would say the following: there's a general rule in favor of injunctions, and absent public interest considerations, such as the ones I noted a moment ago, then an injunction should issue following infringement. That was understood as the general rule of the Federal Circuit. So enter eBay versus MercExchange, a 2006 case. MercExchange owns a business method patent covering an electronic marketplace where a central authority establishes trust among users. MercExchange, however, doesn't operate such a marketplace, right? I guess they tried to operate such a marketplace but failed and then sued eBay for infringement. Those of you who have used eBay before know that they do have sort of trust verification systems as part of the eBay system. In fact, it's sort of a core part of the system, and so that's what MercExchange was suing about. So the district court did not found infringement. Infringement was found in this case. There was really no question about infringement, and the patent was found to be not invalid. So the question is, do they get an injunction? The district court said no injunction because MercExchange had licensed this patent to others. And the court said that no, there can't be any irreparable harm when it seems clear that the patentee allows this patent to be used by others given the appropriate license. And so that was what the court said. The Federal Circuit reversed, said you must grant the injunction, and that the general rule is that the injunction should be granted absent public interest factors. Here there were no public interest factors, so the injunction should be entered. Right? So this goes to the Supreme Court, and the Supreme Court essentially says the following, and this is actually pretty much the entire analysis of the majority opinion. Because we conclude that neither court below correctly applied the traditional 4-factor framework that governs the award of injunctive relief, we vacate the judgment of the Court of Appeals so the district court may apply that framework in the first instance. In doing so, we take no position on whether permanent injunctive relief should or should not issue in this particular case, or indeed in any number of other disputes arising under the Patent Act. We hold only that the decision whether to grant or deny injunctive relief rests within the equitable discretion of the district courts, and that such discretion must be exercised consistent with traditional principles of equity in patent disputes no less than in other cases governed by such standards. That's it. They just say, no, you have to use the 4 factors. You can't take shortcuts, can't have general rules, gotta use all 4 factors, right? So how does it shed light? It basically says shed light on the Federal Circuit's approach. It essentially gets rid of the Federal Circuit's approach, at least in this opinion. So the interesting thing about the eBay versus MercExchange opinion is that there are 3 judges. So there's the opinion that I just read to you, the excerpt, was joined by several judges, but there were 2 concurrences, right? And the only 2 who didn't join concurrences were Justice Thomas and Justice Alito, right? And they said no categorical rules, use the 4-factor test, right? And Justice Roberts writes a concurrence. The Roberts concurrence says, well, sure, you obviously use the four-factor test, and both courts should use the four-factor test. And then it says, after a little bit of analysis, that a page of history is worth a volume of logic, right? And so what does that mean? That's a sort of an odd statement in the case. And what I think that means, right, what I think the court is saying there is Federal Circuit, we should look at the pattern of what's gone on before, and since we have always been issuing injunctions, then it would be fine if we continued to almost always issue injunctions, even if you were still using the four factors, right? So what Justice Roberts says is use the four-factor test. Don't shortcut them. On the other hand, if it turns out that the four-factor test results in the issuance of an injunction in every case or in nearly every case, then that would be fine because a page of history is worth a volume of logic, right? The way that this has always been done, the traditional approach, works just fine. Justice Kennedy has a fairly striking concurrence, and I think it's one of the more interesting opinions that the Federal Circuit has ever written on patent law, and says also that they agree that the four-factor test should be used, and then notes that in many instances, the nature of the patent being enforced and the economic function of the patent holder present conditions quite unlike earlier cases. So this is a pretty striking thing, saying you need to consider when you're considering injunctive relief, not only the four factors, but who the type of patent being enforced, by which he seemed to mean business method or other suspect types of patents would be less likely to be enforced, right? Or the economic function of the patent holder, suggesting that somebody who wasn't practicing the patent, who was merely trying to license the patent or had failed in commercializing a product based on the patent, that was a relevant consideration for whether or not an injunction would issue. Right? He also says, by the way, as part of the concurrence, that the court should also consider whether the patent is likely valid as part of the injunctive relief analysis, which frankly is completely ridiculous, since there wouldn't even be an infringement decision if validity hadn't already been considered. So the thought that the court would have to revisit or should revisit the validity of the underlying patent during the injunctive relief stage is a little bit distressing, that Justice Kennedy thought that was appropriate. But setting that aside, the interesting part of it is that he definitely takes the approach that the courts should use many factors, including the type of patent being enforced and the economic function of the patent holder. So what's going to happen to the law of injunctive relief, right? Lots of possibilities. It's been now 6.5 years, and so we have some sense of what's going on, but not a ton. So one possibility is that over the long haul, not a lot is going to happen. Most courts are going to come out the same way. They're going to issue injunctions, right? We know almost for sure that there'll be additional litigation over entitlement to injunctive relief, right? Because there's no more shortcuts, the entitlement to an injunction is going to be heavily litigated by all parties involved. Are there going to be fewer injunctions across the board? I think that we don't know that yet. It seems like there are somewhat fewer injunctions than there were pre-eBay. And in particular, there are fewer injunctions for non-practicing entities, companies that don't make the products that they're trying to sue somebody for, and business methods, I think, are getting less injunctive relief. But the patterns aren't particularly clear so far. I think Justice Kennedy's concurrence has been quite influential, particularly among district courts. It's not clear how influential it's been among judges at the Federal Circuit. I think eBay has shifted the injunctive relief. I think it's still likely after infringement that you would get an injunction, but it's certainly not the general rule or the automatic that it was before eBay. Right? So eBay might change this idea that we think that patents are a property rule. And there are also a few situations where there are liability rules, right? So pre-trial, where doctrine of equivalence or obviousness is at issue, as we'll find out in just a moment, you basically can't get an injunction, a preliminary injunction in that context, right? Post-trial, where the public interest is at issue, right? Certainly where there's a strong public interest factor, even before eBay, but even more certainly after eBay, injunctions wouldn't issue, and it'd be a liability rule. And then cases involving the government, there's a specific section on the books, section 1498, whereby you cannot get an injunction for patent infringement against the government. You can get damages, of course, if the government infringes your patent, but you cannot seek an injunction for that harm. So that's injunctive relief, and next we'll talk about preliminary injunctions. So the case I had you look at with respect to preliminary injunctions was Amazon.com versus BarnesandNoble.com. It's a 2001 case from the Federal Circuit. So what are the standards for preliminary injunctions? Well, they're really quite close to the traditional factors, the 4 factors, but because of the procedural context, it's all couched in terms of likelihoods, right? And so just to jump ahead here, we will look at the factors are likelihood of success, right? You have to show that there's a likelihood of success on the merits. If you want a preliminary injunction, you have to show that there's likely irreparable harm. You have to show that the balance of the hardships favor the issuance of an injunction, and that there's the public interest factors, either it's not going to hurt the public or in fact favor the injunctive relief, right? And the Federal Circuit has taken the following approach to this. For likelihood of success, you have to show, you being the patentee, for a preliminary injunction, that you're likely to prove infringement. Now, you don't have to prove your entire case, you don't have to show everything, but you do have to show you're likely to win. And then you also have to show that you're likely to withstand of an invalidity claim, right? Because invalidity is such an important part of patent litigation. Simply looking at infringement wouldn't be enough. You also have to show that you're likely to win on invalidity. Irreparable harm is presumed by infringement. Usually follows the likelihood of success factor, although I think post eBay the court now has shifted and is independently evaluating the irreparable harm issue in much the same way that they would a permanent injunction. The question is, would, absent the injunction, something irreparable happen? Would there be, a complete loss of market share? Would the company go out of business? Some sort of irreparable harm that could not be remedied through damages that would come after trial. The balance of the hardships, the Federal Circuit has traditionally said this favors the patentee, but I think after eBay they're being much more careful to balance and try and find a balance of this and say which party is going to be hurt more if an injunction does or does not issue. And again, this goes a little bit to the harm issue as well. And then finally, the public interest, which again the court has traditionally said favors the protection of patents absent some public interest aspect. And again, I think that the post-eBay courts are more careful to consider public interest more broadly, but in general this does seem to favor the issuance of a injunction. So the issue here is, the interesting point is to think about when you might and might not be able to get a preliminary injunction, right? So can you expect to get a preliminary injunction where obviousness or doctrine of equivalence is at issue in the case? And I think you're not likely to get a preliminary injunction there, right? Because you have to be able to show that you're likely to win on infringement. And if the basis of your infringement claim rests upon the doctrine of equivalence, your likelihood seems very low. Right? This goes back to what we were talking about in the doctrine of equivalence context, that it's very, very difficult to win a doctrine of equivalence case. Right? Obviousness is a slightly different story, but if there's a serious challenge to the obviousness of your patent, well, because the law of obviousness is pretty uncertain and the way that we approach obviousness has a lot of uncertainty associated with it, I think, again, it's going to be hard to get a preliminary injunction. Can you really say that you're likely to win when there's a serious obviousness challenge. Now, if there's not a serious obviousness challenge, then you may well be able to get a preliminary injunction. But I think if there's a real issue of either equivalence or of obviousness in the case, that a court is going to be extremely reluctant to issue a preliminary injunction. And so one question is, has the Federal Circuit set the bar properly as a matter of policy for preliminary injunctions? You can see from the Amazon.com case that the Federal Circuit is very reluctant to issue preliminary injunctions during the course of trial. And I think that's largely because they have a strong sense that if there's infringement, then it's unlikely during the time of trial, which is of course temporary, that there's really going to be any sort of irreparable harm, and that any harm that occurs can obviously be accounted for and paid for by damages later on. And so they're very reluctant, and I think they're very reluctant to shortcut the analyses of validity as well. And in particular, this likelihood of success factor is interesting, right? So the alleged infringer needs to show a serious question of invalidity, right? There's a burden shift here, right? So if the alleged infringer shows a substantial question related to infringement or validity, then the burden shifts back, right, to show that the argument lacks substantial merit, right? So it's a burden shifting process. First, the patentee has to make a showing, some sort of showing of likelihood of success, which means likely to prove infringement and likely to withstand a validity claim. If, however, there's a substantial question raised, then the patentee must show why that substantial question lacks merit, right? So it's a shifting burden. So I think this makes sense, and the way that it makes sense is as follows. You have to understand preliminary injunctions in the context of being in a very preliminary context, right? They are often done in an afternoon. There's not a lot of facts on the ground at the time for the judge to go on. And so what the judge is going to want is for, first, the patentee to make the basic case. Why do they think the infringer is infringing, right? And then once that, and why do they think the patent is valid? And then once they've done that, the next question is to ask, well, accused infringer, do you have a defense, right? Is there a defense that you can raise that's a substantial defense? And if that substantial defense is raised, then you go back to the patentee, because you got to remember that the patentee is going to have to prove that they're going to be able to withstand these challenges, or that they're going to be able to show infringement by a preponderance of the evidence, and that they're going to be able to withstand any serious invalidity contentions. And so because of that, I think it makes sense to have this burden shifting given the procedural posture of the cases. But I just wanted to flag that for you so that you knew that it's initially a burden on the patentee, although the burden is relatively low. And then if the accused infringer comes back with substantial questions related to either infringement or validity, then the patentee bears a slightly more significant burden to show that those substantial questions don't have merit.